to all commoners or persons eligible to be commoners. There is lands called commonage, but actually the Act says land held in common. Now there is a myth about these lands, and a myth is something widely held of a belief, but it's actually a falsehood. That falsehood is that these lands on Exuma was formerly that of Dennis Rolle, which was inherited by his son John, who never visited the Bahamas. He was known as the largest land holder, but an absentee slave owner. These lands were held in common, presently held in common. And the myth of John leaving you any lands in his will, he says to all lands in the Bahamas or elsewhere out of England, he told his attorneys to sell those lands either by auction or any way they deemed best. This is the only copy of Lord Rolle's will in the Bahamas, obtained from his estate in Devon, England. You will notice the stamp of the office of Devon. It's a genuine copy of Lord Rolle's will. That means John left us no land. So because of the slaves leave on all of these areas of commonage, that is presently commonage, and these lands are starting from Rollville, Rolltown, Mount Thompson, Ramsey, and Steventon. They're all here, will show you that Rolltown, Mount Thompson and Ramsey, and you have Rollville and Steventon colored yellow. So these areas were troublesome areas. The government had to send the commandant between 1829 and 1833 3 times to the island of Exuma to quell infighting the land. And I'm talking about violent infighting, not just verbal. And they had to send to quell those. So the government made laws. First of all, it made the law called Escheat, which was chapter 41, and it reads as follows: the personal estate of any person who dies intestate without heirs or next of kin, subject to provision of this subdivision, shall acquire such land. So the government made chapter 141 Escheat, which was to escheat, take these lands back, which means the government has a right that anything that doesn't have an owner or next of kin, they will acquire that land. They made chapter 141 of the Act, and the first Commonage Act is chapter 142, which was later changed in 2001, revised to chapter 152. That's 141 up until 2001, and chapter 152 that the government made to control these lands. Now, all of those lands were deeded to Dennis Rolle. These are the grants. Mount Thompson, that's Rollville, Mount Thompson, and there goes Ramsey. I've got them all, but I'm just giving you. These are the grants. And if you would notice, if you go and get one, you will see on top of them escheated, which means it was taken back. So the government owns the land. And the escheat says as far back as 1871. Here's what it says. Provisions to be for the submission occurred to the consolidated funds. So that is where the commonage happens to be, in the government lands of the consolidated funds of lands. Read the Act, chapter 171, section 3. The Escheatment Act, section 3. Our history book, which is Bahamian Loyalists and the Slaves, gives you that very same information I gave to you, which brought about the Commonage Act. Pompey was part of that evolution, which were the Apprenticeship Act, which he took part in. Now, the act itself controls the commonage. The commonage itself has not, there is only one commonage on Exuma that is properly set up. They are not properly set up because the court case, all of these are court cases that either myself or someone else was taken to court in the court cases. There are 17 of them. But the main court case is where the law had a law review. What I'm saying to you right now was done in 2008, where the administrator, the then administrator, sent yours truly to all of the commonages, and we went to Roll Town on Monday the 7th, January the 7th, 2008, on Tuesday the 8th to Ramsey, on the 10th to Mount Thompson, to Steventon on the 14th, and then to Rollville on the 15th. Of the same information I'm giving you, I gave to those commonages. I gave to the commonages the particular of each one of their commonages. On the night of the 10th, going to Mount Thompson, a injunction was taken out that no other meetings be held, and it reads as follows, because I was acting under the authority of the administrator in giving the proper information to all commonages. And it says here, it is ordered the following be granted on return of date of inter partes hearing. The respondent be restrained, whether by himself or his assistant, his servant, or his agent, from any scheduled election, any election of officer, or any other meeting alleged in the Mount Thompson commonage. That saying done, they took out all of these charges on the administrator. The administrator, based on their court case and the witness, then they had a law review and charged the administrator and his agents, which were the people that were charged with the administrator in that law review, were the administrator, Kenneth Nixon, and Ellen Newton, were charged 43 points of wrongdoing in here from one case, and they would show you those 43 points were taken out from chapter 53, rule 3 of the Court Act, section 3, 5, 8, and 9 of the Commonage Act, Chapter 152, Section 10 and 11 of the Commonage Act, and Chapter 37 of the Local Government Act, stating that he violated the Local Government Act by assigning myself and Ms. Newton to take over his authority. The applicants then went on to say that they named Kenneth Nixon and Ellen Newton in there. I declared, because based on the Commonage rules, the rules of the Commonage state that the rules were made for Mount Thompson and Ramsey. And based on that rules, they decided that Mount Thompson and Ramsey is one Commonage, based on the rules. And they decided that because it's one community, and we're operating as one community, that was their point, stating that it was one Commonage. I declared that it is not one Commonage, based on all of the setting and Section 3 of the Act. And this is what they said: that Kenneth Nixon, a non-commoner, I'll read that for you so that you would know what was said in the court about Kenneth Nixon. All through this, it says, Kenneth Nixon, a non-commoner who was directly or indirectly authorized by the administrator to address the said meeting, determined and declared or directed that the Mount Thompson and the Ramsey Commonage consist of two separate and independent entities. I did. It also goes on to say that Kenneth Nixon aforesaid determined, declared, and directed that only persons living or having business on the land up to 1974 and continue to up to their grandchildren are qualified be registered as a commoner. In all of their ruling, on all of their witness declaration, here is the ruling of the court. All of the explanation, it says on the bottom, the Chief Justice of the Bahamas says, I do not agree with the applicants. They lost on all 43 points of the act. And his final submission was simply this: the Chief Justice, who was at the time was the sitting Justice Michael Barnett, Chief Justice, and it reads as follows: in my judgment, pursuant to Section 3 of the Act, each of Mount Thompson settlement and Ramsey settlement being settlement which lands held in common must have their own register of commoners. To pursuant of Section 8 of the Act, annual meeting must be held for the commoners in each settlement for the purpose of electing a chairman and such office bearers as may be necessary. That was done in January 25th, 2011. We were cleared of all 43 points of charges. They then asked for costs and damages. Here is the court order that had to be carried out. And the court order in favor of Ivan Ferguson, Kenneth Nixon, and Newton. And the court says this was done before, upon hearing the application and the judicial review by Stafford, Roll, and Benjamin Roll, pursuant to the rules of the Supreme Court, Order 53, in the matter of the Commonage Act, Chapter 152, 3, 5, 8, and 9, and the matter of Mount Thompson and Ramsey 152, the rules, Section 10 and 11. The matter has been dismissed and has ordered that those meetings that we were carrying on, it is now ordered that the respondent and the co-respondent continued the application of the meetings of regularizing the commonages. It has not happened. In regularizing all commonage, because there is only one commonage law in the Bahamas. All commonage only can go by this one commonage law. Now, there's a subsidiary, the commonage law. The subsidiary act covers their restrictive covenant, which they call rules. All lands has rules. Every subdivision has its own rules. We will get to that, but I like for you to read, it says that the respondents and the co-respondent continue, and that the scheduled meeting of officers for Mount Thompson be held, the scheduled election of officers for Ramsey be held, that the respondent, co-respondent advise and establish the border on both plots of land before the mode of normalcy. So persons who are wondering why I'm still trying to regularize the commonage, it is because of a court order. The court had ordered all commonage on the island of Exuma be regularized. Why hasn't it happened from 2011? Election came up, Mr. Ferguson was transferred out. The other administrator came and stayed about a year and 4 months. He was transferred out. So the whole period, there was no time for any administrator to ever get to regularize the commonage. And I would show commoners that none of their commonage except Steventon are in order. They don't have their registration book. They are not in possession of their registration book. Now here's what Section 3 of the Act states. And it states as follows. This is the reason why the Chief Justice says, I strongly suggest Section 3 of the Act. And it reads as follows. A register of commoner shall be formed and kept in each town or settlement for which lands are held in common. I will repeat that. That a register of commoner shall be formed and kept in each town or settlement in which land is held in common, not held in the commissioner office. It must be formed in the settlement, kept in the settlement. These books, except for Steventon, which I was the assistant registrar, were not holding their book. They were not trained to write in the book, because this book, the registrar, is that of the government and not of the commonage. I want to repeat that. The registry book is that of the government and not of the commonage. It is a book of commoners, but it's not that they are the registered person on the lands that were held or supposed to be gathered in this book for the purpose of the government knowing who is registered as a commoner. Here is the act that tells you exactly that. Section 6 says, where a poison applies to the commissioner, not to the chairman of the Commonage. When properly set up, when the Commonage are regularized, all Commonage will have the same book, studying the commoners, registers of commoners of Rollville, registers of commoners for Ramsey. That is for the government purpose of registered person. Also for persons who want to know where their ancestors are. That's why it's kept in the settlement. If I want to know if my grandmother is a descendant of Steventon, I would have looked in this book and find my grandmother, which the commissioner should have done, as in case of Steventon. The administrator, Bradley and Bristol, walked the settlement and find where every frame of a house was, if it was a floor, who lived here, and then there was a white paper in 1972 which would have told you who had resided in Steventon. And so every house was identified and who was the owner of that house. I'm going to read the reason why. It says, such register shall be formed in the first instance by the commissioner in accordance with rules as may be made and issued to him on the subject by the minister. On the subject, not on that commonage, on the subject of registration. He had told the administrator in 2004 what are the rules on registration in Exuma. That meeting was held on the 2nd of July, where this is his itinerary. And his itinerary says, eligibility to be registered as a commoner. Amount of land any commoner can possess. The authority of executive body of Commonage Committee. Matters that are before the Supreme Court. Rules to be approved. Those are the matters the then Minister of Lands, Mr. Alfred Gray, addressed, and he met with all heads of meeting with executive of all commonage at 6 p.m. He did meet and told the administrator at the time what are the requirements for registration on the subject, which means all on the subject, which reads into that minutes where it was asked the minister, where do we go with these persons who are on the land and some are not eligible to be registered as a commoner. And his words were, revise your register. Yes, we were taken to court for moving persons off the register who were not eligible. We moved persons off the court because he made that order. Although persons made payment for registration, the act says if the commissioner is not so satisfied, he shall reject such application. But if he shall cause the applicant up to be registered as such. So anyone figuring, well, I can take you to court, no, you ain't qualified. They took myself, Mr. Bradley and Bristol, and Oswald Nixon to court under Miss Virgil. And she told them, quite blank, you don't qualify. And so they were removed from the register. That the court case is here. There are many instances. I'm still on the matter of properly set up. The Commonages has a standard registry form which goes that standard registry form must be filled in, and all evidence that is taken is placed attached to this application. So if the administrator appoints a registry of 3 people, an advisor, a registrar, an assistant registrar, and an advisor, an older person advisor to the registrar, there is none set up as yet. A commoner, when registered, are given a card. If the commonage has if any person has any to oppose a commoner, oppose an application, and the act reads as follows. I'm going to read the whole section 6.1. Where a person applies to the commissioner to be registered as a commoner, the commissioner shall consider the application and may take evidence thereon. No one can vouch for you. He must take evidence who you are, who your ancestors are, and where did the ancestors live. Those are the evidence the administrator must take. And it says boldly, any commoner may oppose any such application. I've had a voice note by someone stating that Kenneth Nixon interfering with the other commonages. Out of that person gross ignorance of commonage, it says any commoner may oppose any such application, which means that if I know somebody in Mount Thompson is not eligible to be in Mount Thompson, I should advise the administrator, although he may be Timothy Roll, his ancestors are from another commonage. Please send him to the proper commonage. Any commoner, didn't say any commoner of that particular commonage. Where that happens, I will read further where that happens. It says any commoner may oppose any such commonage. The land is in the consolidation for the government. So therefore, why is it these commoners are of the opinion the other commoner interfering? I will bring you back to that same portion of this non-commoner, Kenneth Nixon, which is stated in the same court ruling. It says, Kenneth Nixon, a non-commoner, had give and directed in a meeting that Mount Thompson. The Chief Justice said to the applicants, are your reverend a commoner? The policeman a commoner? Are the people you doing business with a commoner? Are the people you renting in the commonage, living in the commonage, are they all commonage? Because if that rules come into effect, you can only do business with a commoner. And Mr. Nixon, the only thing that sets Mr. Nixon aside is no person who is not registered as a commoner may have interest in land. Did Mr. Nixon make application for land? No. Well, then why are you calling him a non-commoner? He's a commoner of Steventon. He is a commoner. And all of the commonage has one law that covers the commonage. Now, rules may differ. Your restrictive covenant may differ from one commonage to the other. But the governing rules by the government and the ground has one law, which you must, the mode of operating comes under one law. And I'm bringing that to you today. No commonage except Steventon. There is a license based on the law that before a commoner goes to get a license, which he must pay a license fee every year, the same way he does to the Inland Revenue before he goes to Inland Revenue. This is the Commonage license. And it says Rollville, Ramsey, Steventon, Roll Town, when Thompson is on the license. These are all government documents. And when a commonage is set up, they will have the application all are regularized. All are regularized, and that is what the court had ordered. Seeing it is not ordered as yet, I therefore made this video to inform those persons in the commonage. None of them are regularized under the law. They should have a card like this made up and stamped by the commissioner himself from the administrative office. Must have a seal on this card. I'm in possession of one. Every Steventon person is in possession of a commoner's card. The other commoners do not have it because the order of the court placed on Mr. Ferguson and myself to do that has never been done. That said, that covers you're not set up properly. The rules, a commoner may make rules. Now, they figure they can make rules, send it in, and it's going to be gazetted. Let's read what it says now. Please, let's read commoners. The commoners in any tract of land held in common may, it didn't say shall, may make rules for any of all of the following purposes. That is to say, for the proper laying out of your land. All of these commonages before the year 2000 had a wall around every house, whether it's Rollville, Roll Town, Western Manor. You could have walked through a gate of everybody because the settlements were properly laid out. They would tell you, catch your chicken up, because I planted in my yard. Had a low, in most towns, had a low 3 feet rock wall. And as people replaced those rock walls, up until these persons who been away, come back, move the rock, full in your foundation, and there. The Bible say, young man, do not move the old ancient landmark. The Bible advises you, don't move your landmark. But they moved the landmark. And now they have placed these buildings at random all through the bush. And so you cannot get rules unless you have the land to go with it. And all lands have rules. Every land has rules. Here goes the rules for red land subdivision. This red land subdivision. Here goes red land subdivision. No building shall be erected less than 15 feet from the street. In the commonage, we say no one should burn field less than 12 feet from the other. Same rules, only this time it's for a building or your boundary. No lot should use for the purpose of noxious or offensive. No one, the garden is a different area from the residential area. Says the same thing. No swine, cows, or horse, or poultry. That's what they got to pound. Catch your stuff about the settlement. The same thing in the commonage. These are rules. The same thing goes for Flamingo Bay. These are rules. It says here, not more than one private resident shall be on any numbered lot. All lands, commonage ain't no different. Commonage has rules. All of these lands have rules. Every subdivision has its own rules. These are called restrictive covenant. But what do you think the rules of the commonage says? I'm going to point them out to you. They says no poison, no house. Now let's go into the Commonage Act. All it says is restricting you. No commonage shall cultivate any land within 12 feet of another commoner. Same thing in this restrictive covenant. Nothing changed. Yes, let's go to this. No commoner should buy in field or within 100 feet of another commoner. Same thing that says no obnoxious or no building erect in there. No swines, no unlawfully mauled. The same things. These are the same laws. When you see all the lands, these are restrictions on land. And you know what the laws do? Restricts yourself. The rules restricts yourself. The law gives you privileges. Rules are restriction. I will turn another page in here and it will show you what it says here. No person should carry on trade or business upon the commonage of the settlement of Mount Thompson or Ramsey unless and until they receive a license from that commonage in respect of that trade or business. A license. And every year you want to renew it. And unless we get regularized, where we say to the Inland Revenue, whenever they apply, if they don't give you a copy of the license from the commonage, there shall be no license. Because you are making money of the commonage. There's a business going on. And there is no remuneration to the commonage. So these things have to be properly laid out. Now, let's go to the election. It says here in section 8 of the Act, for which they take us to court for election. Says, there shall be an annual meeting of commoners of any lands held in common on which the first Monday in the month of December, an annual meeting, the commoners shall elect a chairman for the ensuing year, and such office bearers as may be necessary. In default of their doing so, the commissioner may nominate the chair and such office bearers. Commonage is a statutory body, which means the officers must be a citizen of the Commonwealth of the Bahamas. Now, commoners, all of these books I'm going to show you is pertaining to commonage. Every one of these books, and I'm going to read for you, says here, for any statutory or general election, the entitlement is unless on the day which he applies, he is a citizen of the Bahamas of full age and not subject to any legal incapacity. Must be a citizen of the Bahamas to hold a statutory office. Must be a citizen to vote. This is the registry, parliamentary registry book. Must be a citizen of the Commonwealth. That's the law. Must be a citizen of the Commonwealth of the Bahamas. To take part, he cannot stand on any statutory body. Commonage, as ruled in the court, in the case, is a statutory body and must follow the statutory rules for that particular body. Each one of the body, town planning has it. Port Authority is a statutory body. Local government is a statutory body. Since you're unbelievable in that, I'm going to go this far. And many persons, as simple as me being a citizen of the Commonwealth of the Bahamas and a resident of Exuma, I lived in East Township. I cannot go to a meeting in West Township. I will read as follows. A town meeting shall be held at least once a year, called to the town area meeting, which shall be open to persons appearing in that part of the register relating to that town area. I can't go out west to go and open my mouth in their meeting because the Local Government Act says you cannot do that. So that's pertaining to commonages. If you are non-Bahamian, and if you ain't registered, I can't go to these people's town area meeting. So how could I hold office and be a voter in that area? My name do not appear in that part of the registry. I'm gonna go to this book. I said all of these pertaining to commonage. Here's what it says in section 3 of the Foreign Person Landholding Act. We had to go through this in Steventon. There are persons who have children who are American citizens. It reads as follows. A non-Bahamian, other than a permanent resident, shall acquire land or any interest in land under devise or by inheritance, who intends to acquire land, either by a freehold, lease, or acquisition, is not within section, shall obtain a permit from the board to make the acquisition. In the absence of that acquisition shall be null and void without effect for all purposes of the law. Now, I will show you, this is the other book. A non-citizen of the Bahamas, reading section 13.2 of the Town Planning Act, says care should be taken to ensure that Town Planning Board shall not permit application made to persons who are not a citizen of the Bahamas. But they apply these commonage grant these persons. Here is the permit. And the permit from the Investment Authority would say as follows. Permission is hereby granted you to acquire the following property, at which property is there, for a vacation home. If in the absence of that permit, if you're a foreign person and you don't come, you come to the commonage, you must have that permit. Commonage, as Mr. Gray said, is for commoners to live on. Was not given for your vacation body, it's for you to live on, or at least live near. But it's strictly stated out that the International Land Person Act. Now, in a holding meeting, section 10.7 of this act states as follows. Because persons say, we, the executive, hold a meeting, and the executive decided. The executive hold a meeting, and the executive decided. You see, the reason why persons like I sets out to protect these lands. These lands are the only thing left that has not been sold in this country. And if you allow one commonage to mess up and do what they feel, it bleeds over to the next commonage. Yes, we can say, well, let us do this in Steventon. Why we can't do this? And the law is made up from what is the norm. What is the norm becomes the law. So if you allow one commonage to go and dictate their actions to the rest of the commonage, which is detrimental to my children, to my descendants, that's where I step in. And I living in one commonage, and it says, any commoner may oppose any such application. Now listen, where that same part of the act is played out. It says in 13, every person who does not comply with the requirements of the rule, they give a penalty. And every penalty may be recovered summarily by any commoner or any peace officer. The peace officer ain't no commoner, but the peace officer, which I am, can set that this rule, this law in here that regularizes us is not being carried out. So any commoner can do that and take you to court summarily. Let's go further. Any person aggrieved by the decision of the commissioner shall have the right to appeal to the stipendee and secretary magistrate. The administrator is not above the law. This magistrate was taken to court, for which I was the expert witness for that case. He won the case. He was taken again to the Supreme Court. Same administrator taken to the Supreme Court. Mr. Ferguson was taken to court. The administrator is not above. Bradley and Bristol was taken to court, where along with me and my cousin. So the administrator, based on the Commonage Act, is not above the law. And if he does something or gives instruction, any decision made by him, take him to court. And believe you me, he will be on his own, because the other place ain't gonna send him no lawyer. Because if they see you violate it, they will leave you on your own. That administrator stand up to the bar, just like every other criminal, in front of the magistrate. And so, here is the only thing the administrator could decide on. When these rules are put in place, in any proceeding against any person offended against any of these rules, no question of title may be raised, and the commissioner has the full power to try in such proceeding. The rules, not land. The administrator or magistrate cannot interfere with land dispute. And most commonage problems are land dispute. I will draw that sufficient for that. It says, commoners may hold meeting, and all question arising for decision shall, at such meeting, shall be decided by the majority of commoners present at such meeting. Now I know there's some people using electronic means. That was allowed up until January 2023, when they went back to Parliament and removed all visual electronic means from the courts or any other statutory body. Town planning, we used to have it, but the video means are prohibited by law, prohibited by this law. Now listen where it violates the law. All questions shall be decided by the majority of people present. But when you got people on this video means throwing in all this interference with the decision, it's a violation of Section 7. And where I find it, I will bring it to the court's attention. Section 7 is a violation where you, who are here in the room, drinking your coffee. So take, for instance, if that is allowable, everybody can stay home. Is it? Ain't only for some people who ain't on. Everybody stay home then. Give me the link, and everybody stay home. So who is present? Nobody. So you're practicing something that's going to affect you. Because the day will come where everybody says, well, I can stay home and get the link. So that violates that the interference of those decisions are not only done by the people in that room. It's being done by some people who sipping their coffee in their living room That is a violation of Section 7. And hear what it says. Provided no resolution at any meeting shall be of any force. So this executive thing, where you get the 10 people from, when there's only 4 people on the executive body? The chairman or the vice, the treasurer or the assistant, the secretary or the assistant, one of each. They don't make 2 offices, they're only the same office bearer. One is assistant, so there's only 4 persons that are executive. The chairman and the vice chairman can be in the same seat at the same time. So it's only 4. So where is executive when it says, and there shall be no resolution at any meeting, I don't care what you call it, executive, whatever you call it, at any meeting shall be of any force unless there are 10 commoners present at such meeting. Committee, officers, executive, big boys, whatever you call it, 10 commoners, regular commoners, must be at that meeting. Now, the land committee, how does it work? The land committee is just the same way our parliament works with the ministers. He is the minister of land. The meeting is held and opened by the commoners chairperson. There are 2 chairpersons elected, which are the chairman of the man and the chairman of the land, which means the chairman that is elected for the commoners and the chairman of the commonage, the land, has to be, because he's the person with all the records of the land, when they go, which land time has run out, which allocation of land. But the chairman over here is only a secondary signature to the treasurer, to the secretary, to the land committee, but not the boss of anything. They're only chairing the floor. The same thing, once the business part of the commonage has been carried out by the chairman of the commoners, he passed the people over to the land committee, where the land committee takes over the floor, the same as parliament. He comes in and says, here's what we have, here's the application we have, here's a little problem with some people in the land. That don't be presented, but I say presented by the chairperson of the commoners, and they have the rules of operation the same as this. The chairman of the commoners is not the chairman of the commonage. The chairman of the commoners see that sick people attended to, persons are assisted with funeral or burial, assisted with the sick people. These are what the chairperson of the commoner do. Makes individual committee to attend to individual things, fundraising, whatever it is, that comes under the commoner, the chairperson of the commoners. One chairperson called me while I was, voice messaged me while I was the chairperson of the town planning, where I said, I want me. I gave all the particulars to the chairman of the land. I don't deal, town planning deals with land. You inform the chairperson of the land of what's going on, who make representation to their community of what is supposed to be done. But the chairperson who sits there believe that they are the boss over the chairman of land. That's the reason why they says in here, a chairman and all such office bearers that may be necessary. He's elected just like you. That chairman wasn't appointed by the chairman of the commoners. They were elected by an elective body, and they have the same authority over what they was elected for. So commoners, the chairman of the land can't give you nothing unless he take it to the floor of that same meeting. So the chairman of the commoners, because the commoners, he or she is standing to the commoners, who the land chairman has to answer to. And see, it's not regularized and set up properly. So everybody has a power. It's a power struggle within the Commonage. Another thing of electing people. Do not elect a body of people who never could have worked together. That random election, you would be there all year and nothing happened. But the commoners, if they would go with teams of persons, Commonage is only family. So forget the story, but only one family on the committee. That's Commonage. In every Commonage, you only got two families. If one family goes in, they try to fix up everything for their side of the family, which should not. And I'm going to give persons who have been barred for some time. Wherever the rules are violated, the law says right here, any offending against any provision or any of the rule, I'm entitled to have land. So the land chairman may not give me anything. And any application that goes in 1 month, and 2 months later, there is no answer. Here is the fact, and I will assist you. That is my duty, to assist in regularizing these commonages, so says the court law order. And I can issue that court order and walk into any meeting based on this court order with a policeman. And if I rap on the door and you don't pay attention to me, I continue rap until you pay attention to Kenneth Nixon. That is the order. So what it is, if you fail to assist that land person, fail to assist that applicant, take that same keep a copy of your application. Always when you send in an application, even to immigration, keep a copy, because they always would say, file was lost. So you will have your record that I gave an application. This is the copy of the date. The administrator has the full power to determine the issue on your Section 13, 14. He has the power to determine the issue, but you got to go to him with evidence. The story that runs on is not valid. I'm going to give this part where it says that construction in Commonage. See, Commonage, like I told you, all of these books is pertaining to land. Lands held in common. Here's what happened. The building control officer shall, subject to payment of the prescribed fee, grant a building permit upon being satisfied, now listen now, that the proposed building complies with the act and the rules and meet the standard and specification provided in the building code, and that any license, a license, ladies and gentlemen, a LICENCE is different from a LICENSE. And you would see a LICENCE says here an official permit to own. A deed, a permit, that's a license. But if you get a LICENSE, that's hanging on the car. That's the freedom to do something. License and license are different. One is the noun, the name of something. That is your deed or your conveyance. And LICENSE is a verb. Freedom to do something. A freedom to go on the road. I got a license plate. To sell liquor, I have a liquor license. The freedom to sell liquor. So there's a difference between that word. It ain't no English and American. It's one straight word, comes out of the dictionary. which I just shown you, that comes out of the dictionary and says, out of the law dictionary, says license and license are two different things. So it says here that he is satisfied that you have a license or permission required under any law. Under the Commonage law, requires a permission to build in the Commonage under this law. And it says, if the building control officer, if not satisfied that you got the right permission, the chairman of the board could say, this ain't the right position. This signature on here ain't right. The format of the application ain't right. Send that back. He shall refuse to grant the permit. So Commonage is a lease. You are land. What your internal operation is may differ from Commonage to Commonage. But the day you step out of that, you got to comply with all of these books. The day you step outside your wall gate, all of these books you got to comply with. You ain't no more in the Commonage. You out of the Commonage. So your rules only restrict you. It does not restrict the fella in Pharmaceville. It says no commoner in Stevendon shall. No commoner should do this. It's a restrictive covenant like every other land. Every subdivision on the island has its own rules and must be complied with before you could build. And every one of those rules come under these same books. So in approving any application or anything, now your mode of operation within your Commonage or the rules is a different thing. But the day you step out of there, you have to comply with the outside rules. I'm going to bring to your attention some things that as recently, because I know these commonages, as recently as 22nd of September 2023, the Supreme Court had ruled that certain area does not comply, and I'm going to read where it was brought up. There was a court between Malone Sr., Malone J. Sr., and the Pinder State versus Pinder 1985, BHSJ, case number 54. And it says it found on an application for an interlocutory injunction that Roll Town did not satisfy the statutory definition. See, these are the things that commoners do not understand Commonage. And I'm going to read that after I break down some court case for you. There's a court case in here where yours truly, the church took everybody to court, not the church. A family member took St. Andrew's Church to court, and it placed them to court for Stafford, the reverend, the trustees, and everybody was placed in court. They were placed in court because yours truly took it upon himself to grant these people 8 feet on the Roach's property to build a bathroom. I was taken to court along with all the church trustees and everyone for interfering with their land. There is the court ruling. See, because there are things, if you are not a commoner, you could bring a lord from England. If he has never lived in Commonage, he will never understand Commonage. For one, here's this case that the Roach took the commoners, everybody to court on that same little 8 feet. Now, the church is the Roach Church on Roach Hill. It's taken to court by a roach for a toilet, for a bathroom. And it would rule against us that we had no authority. The committee had no authority to grant a land within the settlement, the confines of the settlement, had no authority to do so, even though it was about the Roach family. That is something ought to be settled among the family, to grant piece of what they had. But I took it upon myself, man, that's a church. You know, they ain't gonna do that. But a brother and sister took the pastor, the trustees, and some of the members to court, and that's the ruling of the court. Let's take another matter. Another matter where I was again taken to court by someone says their mother, this court case right here, the mother gave him the portion of land that was given to his grandmother, but transferred down to him without the authorization of the Commonage. And he took it to court, to Supreme Court. So I'm standing Supreme Court, and the court asks the attorney who takes us to court, where's the title? He don't have no title, piece of land, paper he get from me. He said, my learned friend, you come to court with a title. And if you didn't have anything from the commoners that grants him that land, his mother cannot transfer land to him. In no way, whether by way of document or by way of will. Lands don't have no title. If the land has no title, you can't transfer land. It was given to your grandmother to use, she died, so she have no further use. If she give it to that and it's still vacant, where's the occupation? Occupation gives possession in Commonage. You should read section 3 and says every person who residing in the settlement and in actual occupation is entitled. So occupation gives you entitlement. Vacant land, you don't own vacant land. Here's the other point. It has the government put on commonage land. If you look in every rule, everywhere, there's a 3-year period to operate. If you get Crown land, they give you a period to start developing. The last ruling on lands purchased from government is 2 years. So here's the fact. Lands left for 3 years is considered abandoned. Let commoners and these land committee knows abandoned means nobody own it. I give it to John leave it. I cannot go and take possession. Lands in commonage automatically fall to the next person, which says any commoner may take possession and use, because it's already given out in your arsenal to give out again. You cannot give that out again except it's abandoned, and some commoner take it and comes to the commonage and say, now I'm in use of this land, and inform you in use of a land that was given out to Henry. Henry has no more interest in the land. These are the standard setup of commonage. You don't operate beyond the law or your feeling for which family you would do or your family don't. I'm saying to commoners, if you need and you figure you was wrong, I will assist you, because none of the commonages are standardized as the law requires. It says that roll term does not satisfy the statutory definition. I'm saying to these people, unless you could prove to the land minister you have been operating for a period of time, then you will find yourself in the category, as they say, Roosevelt was found to be as lands held in common, because the court found out they had a record dated back to so much years, give more than 12 years, giving them the status of lands held in common. So commoners, please, your commonage needs to be regularized. You need to have your book revisited, and those who are not qualified under this act are to be removed. Under the past minister are to be removed from there. And you non-citizen cannot hold office or vote in any statutory election. Commonage is statutory. I trust that if you need information, I will give you those documentation with the information on it. Kenneth Nixon, 803-3242.